Good morning.
Good morning, Judge. Are you able to hear me okay?
Yes, we can. Go ahead when you're ready.
I can't hear you. Are you Mr. Smith?
I am.
Okay, perfect. Now before the court is Jeffrey Smith. In this matter, this is the third bench warrant after failing to appear on September 11th, 2024. Front of the court is requesting in this matter that the next hearing be set for October 30th at 8 a.m. Current bond is set at $3,267, and last payment in this docket was through income withholding on May 13th of 2024.
Mr. Smith, in this matter, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on October 30, 2024 at 8 o'clock a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Not that amount, no.
Okay. Well, what I'm going to do is reduce the bond in hopes that you could be released. You obviously have a substantial arrearage in this matter. I'm going to set your bond in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
No, Your Honor.
Okay, thank you. You're free to go. Have a good day.
Mr.
Thank you,
Freeland
too.
failed to appear on March 5th of 2024 for a show cause hearing before the referee. This is the first bench warrant in this matter with bond presently set at $1,574. Front of the court requests next hearing be set for October 30th at 8:45 a.m. for this court. Mr. Freeland has never made a payment in this docket and reports a new employment at Speedway.
Yeah,
Thank you.
I just spoke on it.
Mr. Freeland, you're charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on October 30, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I just spoke to the lady, I don't know who it was, on Thursday down at the courts, but she was offering to work with me because I just told her the child support's been charging me $1,200 a month for working at American Axle, and I haven't worked at American Axle in over a year now, over almost 2 years now, and they've been overcharging me. And I just started working at Speedway, and she told me if I could come on Monday and with $200 and come inside there, that I wouldn't get put in jail. But I just got put in jail on accident. But but I won't be able to get no money if I'm not going to be able to go to work.
Well, if the support is set incorrectly because of a change in jobs, you have a right to file a petition to modify that support, but it's up to you to file the petition. So
yeah, that's what. Well, she said the lady said that she was going to help me after I came up here and got put on a plan and put some money down on it towards it.
Okay. Well, what I'm going to do is it is your first warrant, so I'm taking that into consideration, but also considering that you've never paid on this account. What I'm going to do is reduce your bond to the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
Is there any way I would be able to do a PR bond or something? Because I still have another.
No, we don't do PR bonds, so has to be
Or
a
like or 250 or something, because
$300 is the bond. Okay, thank you. You're free to go. Have a good day.
I think that makes sense.
219 DP. Mr. Evans failed to appear for an adjourned show cause hearing before the referee on August 22nd, 2024. This is the first bond. I'm sorry, the first bench warrant. Bond is currently set at $520. Last payment made in this matter was June 24th, 2024 through income withholding. He reports no new employment at this time, and front of the court's requesting that the next hearing be set for October 30th at 8:45 a.m. before this court.
Thank you. Mr. Evans, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on October 30, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, I am not. Can I make a statement real quick?
Go ahead.
I do not know what address you guys have on file, but I was not even aware that I had court.
Okay.
I have never got anything in the mail or anything. All my court paperwork normally comes to my address, but I have never received nothing from friend of the court in my address at home.
Okay.
I didn't even know I had court.
If you've changed your address, you have to keep that front of the court
My-
notified of that.
My address has been the same for almost 3 years.
Okay. Well, we don't know what happened. I would say that the mail is not always dependable, and that it's unfortunate.
Okay, yeah, I wasn't even aware that I had court.
Okay. Are you able to post a bond, sir?
No, I am not.
Okay. Well, it is your first bench warrant, so the court's taking that into consideration. But you
I
haven't
was supposed to
paid,
start my job today so that I was
haven't
able
paid
to.
since June 24th, so I'm taking that into consideration. What I'm gonna do is I am gonna reduce your bond. I'm gonna set your bond the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
Nope.
Okay, thank you. You're free to go. Have a good day.
Judge, did I hear you right on Smith? That one's 300?
Smith was 500.
500, okay. And then
500, Freeland was 3, and then this was 2.
2, got it. Thank you so much.
Okay, have a good day.
Okay,
We'll see you Wednesday. Witnesses
you too.
in the matter now pending to the best of your ability.
I do.
Court will note the appearance of Ms. Henderson on behalf of the plaintiff, Mr. Umlauf on behalf of the defendant. This matter is before the court on the plaintiff's notice of presentment of default judgment of divorce and
For the-
defendant's motion to set aside default. Ms. Henderson, you can proceed.
Thank you, Your Honor. Could we please swear Ms. Lemus Duran in?
Sí, lo afirmo. Yes, I affirm.
Okay, go ahead, Ms. Henderson.
Thank you. Ms. Lemus Duran, did you file for divorce in early 2024? Did you attempt to discuss the judgment with your husband despite the default?
Sí, varias veces. Yes, several times.
Did he refuse to participate?
Se rehusó él en participar. Sí. Yes,
Do you insist that entering the judgment today is equitable?
yes,
In your complaint, you stated that there was a breakdown of the marital relationship to the extent that the objects of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage could be preserved.
no.
Could you please state to the judge what led to the breakdown of your marriage?
We already had very bad communication. We had many problems and I tried to solve them and we went to a psychologist to have therapy.
Y él no quiso aceptar nada.
He didn't want to accept anything.
No me gustaba cómo trataba a mis hijos.
Before that, there was much, I didn't like how he treated my children.
Is there any reasonable likelihood that your marriage could be preserved?
No.
Are you asking that the court enter the judgment and the child support order today?
¿Cómo?
Él está pidiendo a la corte que presente el juicio y que además presente la parte de manutención de los niños en el día de hoy.
Sí.
Yes,
Thank you, Your Honor.
gracias, su señoría.
Ms. Lemus Duran, are you currently working?
Yes.
And what is your annual income?
It's weekly $707.
How much?
$707 a week.
Court does note that Ms. Henderson had requested the interpreter in this matter, but based upon the income of the plaintiff, the court does believe she can in fact afford the cost of that, so the court's going to order that the plaintiff pay the interpreter.
Yes, Your Honor.
Okay, thank you. Okay, Mr. Umlauf, you want to proceed with your motion to set aside?
Yes, I would, Your Honor. This matter was filed on February 7th of this year, and my client, Santiago Guardian Valdivia, was served on February 9th, 2024. On February 26th of this year, my client participated in a hearing on the plaintiff's motion for temporary custody, parenting time, child support, exclusive use of the marital home, and other relief. The court entered a default against my client on March 19th of this year. At this point, the court has not entered a default judgment against him. My client had a good reason for his failure to answer the complaint. He does not read or speak English and therefore was unable to participate in the case until he hired me, as I read and speak both English and Spanish.
Como-
Furthermore, For the majority of the pendency of this case, he did not believe he would need an attorney because the parties were in agreement on matters of child custody, parenting time, and child support. And he was not aware until he received the proposed default judgment of divorce that the plaintiff intended to include as a marital asset in the judgment a property in Mexico that my client does not have an ownership interest in. After I requested proof from opposing counsel that my client did have some sort of interest in that property, opposing counsel sent me 3 photographs that purport to be a contract for the sale of that home. However, the photographs of that contract do not have any of the appropriate markings or seals showing that it has been registered at the appropriate state agency in Michoacan. And the signature at the bottom of that contract does not match my client's. We are requesting that the court set aside the default that has been entered against my client and that my client be allowed 7 days to file an answer. And to be clear at this point, the issue that we are disputing is property and debt division only. Thank you, Your Honor.
Gracias, Su Señoría.
Any response, Ms. Henderson?
Yes, Your Honor, thank you. As Mr. Umlauf stated, there is a default entered in March of 2024, which is approximately 7 months ago. In order to set aside default, the moving party must assert good cause or meritorious defense or both. Good cause is a legally sufficient reason for the court to do something. The fact that the defendant does not speak or read English in this matter does not constitute good cause. Plaintiff also does not speak or read English, but plaintiff has made arrangements to have an interpreter present at court proceedings and during our meetings. There was an interpreter present at the February motion hearing to make sure both parties were able to understand and participate. Meritorious defense is a legal argument that would allow the court not to apply a certain rule against a party. There is no evidence of meritorious defense in this matter, Your Honor, as plaintiff's counsel was advised by defendant's counsel back in mid-May of 2024, over 5 months ago, that he may be getting on the case. However, Mr. Umlauf was not actually hired by defendant until October. Further, the judgment of divorce was prepared on the information provided by my client, as well as some documents that she had from defendant. The adult daughter of the parties acted as a mediator between them and assisted them in translation of the documents. That adult daughter attempted to involve and engage Mr. Guardian Valdivia in negotiations and at least communication with her mother regarding the judgment. Originally, the judgment was actually prepared as a consent document for both signatures. Mr. Guardian Valdivia refused several times to review that judgment with my client with their daughter present. Regarding the argument about the property in Mexico, we understand that Michigan State Court does not have jurisdiction over the property in Mexico, and that property is mentioned as being awarded to defendant with him performing whatever documents would be necessary in that country to perfect his interest. The parties have consistently used that property during the marriage as marital property, and never once did defendant make an argument that it was not marital property. The copy of purchase agreement for that property listing Mr. Guardian Valdivia as the purchaser was provided to Mr. Umlauf. Neither myself nor Mr. Umlauf, to my knowledge, are licensed in Mexico to know exactly what documents are necessary to record or register real estate interest. And it would be unjust to set aside default now, Your Honor, over 5 months after the original notation that Mr. Umlauf might be getting on the case, simply due to Mr. Guardian Valdivia's delay and negligence in retaining counsel if he wanted to have one. For all of those reasons, we're asking that the court enter the judgment and the support order that have been approved by the friend of the court and allow this case, which is over 255 days old today, to proceed to closure. As stated earlier, we have made numerous attempts to engage in negotiations with Mr. Guardian Valdivia, and he refused. And the reasons stated by Mr. Umlauf do not constitute good cause or meritorious defense. Thank you, Your Honor.
Thank you.
Your Honor, if I may respond.
Yeah, Mr. Umlauf, if in fact your client's receiving the property in Mexico, how is there an issue still, and how is that inequitable?
Well, firstly, Your Honor, he doesn't have an ownership interest in it. And secondly, and more importantly, if it is awarded to him in the course of the judgment of divorce, it affects the division of property and could affect his ability to get an equalization payment since the marital home is being awarded to the
Okay.
plaintiff.
Mr. You must
Apologies.
repeat that because, see, secondly,
And secondly, and more importantly,
y más,
if it is awarded to him in the judgment of divorce, that would affect any potential equalization payment since the plaintiff is being awarded the marital home.
porque la demandante se le está dando el hogar marital.
Your Honor, just a brief response regarding the value.
No, Ms. Henderson, I don't need anything else.
No necesita nada más.
In this matter, the court will find first that the testimony provided by the plaintiff does meet the statutory basis. There has been a showing there's been a breakdown of the marital relationship. Court believes that the reasons given by defendant that he could not read or speak English
De que no puede leer o escribir en inglés
and that he did not need an attorney
y que no necesitaba un abogado
is again inconsistent with the fact that we had a hearing
es inconsistente con el hecho de que tuvimos una audiencia
on February 26, 2024, as well as all the admonitions he received to meet at least with the adult daughter, and that he had met with Mr. Umlauf back in May.
y que se había reunido con el señor Umlauf en el mes de mayo.
As a result, the court will find that there is not good cause to set aside the default,
La Corte encuentra que no hay buena causa para quitar el juicio por defecto,
but the court will allow the defendant to be involved for purposes of the disputed property and debt issues. We'll send the matter to mediation.
enviaremos este asunto a mediación.
Mr. Umlauf, who would you like as a mediator?
Señor Umlauf, ¿a quién le gustaría tener como mediador?
Mr. Brundage, Your Honor.
Señor Brundage.
Ms. Henderson, is Mr. Brundage sufficient?
Absolutely.
Okay.
¿Es el señor Brundage suficiente? Sí, señor, absolutamente.
Mr. Umlauf, I'll ask that you would prepare an order that states that your motion to set aside default is denied, but that your client can be involved to dispute the property and the debt division, and that it'll be set for mediation with Mr. Brundage. And Mr. Umlauf, when you have a date set for mediation, contact the court, let us know so we can set up a settlement conference. And you can submit that under 7-day notice of entry, Mr. Umlauf.
Los 7 días de dar noticias, señor Umlauf.
Thank you, Your Honor.
Thank you all. You're free to go. Have a good day.
Gracias a todos, se pueden ir, tengan un buen día. Miss Henderson, can you give me your phone number? Thank
269.
you very much.
Thank you.
Have a great day.
You too.
Can I ask you a question?
Yeah.
Could she use the microphone? I'm hard of hearing and I'm having a little trouble hearing her.
Well, she's not going to be talking, so.
Okay.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to enforce judgment of divorce. Ms. McNiff, you can proceed.
Your Honor, this is a pretty simple, straightforward case. The parties agreed in their judgment of divorce that they would equally divide all of the college expenses for their children. Their oldest child, who is still 18, mom has now expended $7,987.55 on her college education for this year. Mom will be paying $2,578.33 each month going forward. She's already paid the October payment. Dad has not contributed. Mom has sent numerous emails to Dad asking him to contribute that portion that he's responsible for pursuant to the judgment of divorce without any effect. And we're simply asking that the court enforce the judgment and require Dad to uphold his end of the judgment of divorce agreement.
Okay. Sir, what's your response?
Sure. Can I have I'm going to ask for an adjournment. I just got the letter on Tuesday this past week, and I've been trying to get a lawyer. I'd like to hire an attorney to help represent me in this and speak about my legal rights.
Okay. What the court will do, the court will adjourn the matter 1 week. It'll be set for next week, the 28th at 9 o'clock. So you'll need to have your attorney present at that time, sir.
Is this something that could potentially go to mediation? I think
No.
there's some
No.
prior to my daughter going to college, I tried to meet with Mandy and my daughter about this. Basically, my daughter I'm supposed to have joint custody, and for the
Okay,
last.
sir, hold on. You want adjournment. Don't argue the case. If you want an adjournment, we'll come in with counsel then next week.
Yeah, okay, that's fine.
Okay, court will adjourn the matter 1 week.
Thank you, Your Honor. Do you want me to renotice that,
Thank you.
or will we just show up?
No, you can just show up. We'll set it.
Yeah.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff, Mr. Umlauf on behalf of the defendant. This matter is before the court on the plaintiff's motion to enforce judgment of divorce. Ms. McNiff.
Your Honor, we were here before last week and the court adjourned. This issue is primarily, the only issue is Dad has not been paying for his portion of the child's college expenses. I've read Mr. Umlauf's motion, and in response, we would tell the court that Mr. Dubiel has had access to the child's tuition statements. My client made sure that he had access. We don't believe that he has set up an account, but that would be on him to do that. He was sent an invitation. I sent that information over to Mr. Umlauf early this morning. He may not have had a chance to look that over. We also have sent Mr. Umlauf a copy of the 529 account. The 529 account only has about $4,000 in it, and it was my client's plan to save those funds until the child's senior year when expenses would be heavier. $4,000 isn't very much. It's not going to pay for her college education. It may cover part of one semester. But at this point, the parties have a deal. The judgment is very clear that they're to share those college expenses. The child is going to Northern Michigan University, which is one of the less expensive universities, public universities in the state. And we're simply asking that the court enforce the parties' agreement.
Okay, thank you. Mr. Umlauf? You're muted, Mr. Umlauf.
Apologies, Your Honor. I didn't realize I was muted. I have not seen the email that Lisa sent me, so I haven't had a chance to review it. As it relates to the expenses, my client has not been has not had access to a good portion of the information that the plaintiff has had access to. He has only been provided verification for the books and the enrollment deposit. He has not been able to see any of the other supposed expenditures, and we are asking that verification be provided. If some sort of link was sent to him to allow him to sign in, he either didn't see it or didn't understand what it was when it was sent to him. Furthermore, there is a 529 account with approximately $4,000 in it per the information provided by the plaintiff. We haven't seen an actual statement yet. As I understand, Lisa sent it to me, but I haven't read it yet. But we would ask that that be used first before the parties have to spend any of their own money on the minor child's college education. And finally, Your Honor, this is a situation where my client has not been involved in any dialogue with either the plaintiff or the minor child regarding her college education. And so he has really been, in essence, the only dialogue that he has had is receiving emails from the plaintiff requesting that he pay the bills. My client understands that he should pay that he's required under the terms of the judgment of divorce to pay for half of the minor child's college education, but we are asking that verification of those expenditures be provided to him before he actually be required to pay them, rather than simply taking the plaintiff's word for it. Thank you.
Thank you. Well, what the court's going to do in this matter is, it doesn't seem, if the child has a 529 plan, it doesn't seem reasonable. The child just started that we're just going to wait until the child's senior year to utilize that. So the court would order that any amounts in there would be utilized first in this particular matter, that any balances after the utilization of that would be again paid for in this case. So by the parties equally as per the provisions of the judgment of divorce. So I don't know how much is in there or how much you're going to have to, Ms. McNiff, figure that out, apportion it to the, I guess, to what's been paid at this point. And again, the defendant would be responsible for his 1/2 the cost of that. And I'll let you, Ms. McNiff, provide Mr. Umlauf with the amount that is due. The court would order that he would pay that amount forthwith. And that, again, the plaintiff would provide any, I guess, provide him with that link to get into the account so that he can view that or see what the expenses are, et cetera. Further, that she would provide the verification of the expenses that she had paid and then what the amount is owed to him. And then the court will reserve on any attorney fees or costs in this matter. So, Ms. McNiff, you can prepare that order and submit under 7 days.
Thank you, Your Honor.
Okay, thank you. You're free to go. Have a good
I'm
day.
hanging in.
Thank you, Your Honor.
We do not have Mr. Scobie, so,
Mr. Scovey is in the hospital right now.
okay.
So I mean, I don't know if we want to go on the record, and I can say that on the record.
Okay, yep, I'll bring Jamie in here.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff. This is plaintiff's motion for temporary custody. Parenting time is so are Ms. McNiff.
Your Honor, it's my understanding that Mr. Scobie was hospitalized this weekend and he remains hospitalized. We don't know if he has the ability to get onto Zoom or is in any condition to get on Zoom at this point. I don't have any objection to adjourning for a week to see where he is. However, in the meantime, I don't know if the court would be inclined to enter an interim order. Clearly, Mr. Scobie can't care for the party's child while he's in the hospital.
Well, I'm not going to do an order if we're adjourning it. We'll adjourn it 1 week and address everything next week.
It looks like we're just going to have a lot of hearings next week, Your Honor.
We probably will.
Thank you.
Court will note the appearance of Ms. McNiff on behalf of plaintiff. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. Ms. McNiff.
Your Honor, we were thorough in our motion regarding the difficulties with Mr. Scobie's health in terms of taking care of his 6-year-old. It's my understanding that Mr. Scobie was hospitalized until last Wednesday, and upon leaving the hospital, went and picked the child up from school and kept the child. There was some police involvement at that point. We do not believe that Mr. Scobie is capable of caring for this child on a full-time basis. It's further our understanding that Mr. Scobie recently acquired a cat, and when Ms. Scobie asked him how he was going to take care of it, his reply was that he was going to have the child take care of the cat, clean the litter box, feed the cat. Our position is simply that Mr. Scobie couldn't take care of himself without the assistance of Mrs. Scobie in terms of dressing his wounds, which are significant, and making sure that he had the antibiotics he needed for ongoing infections. And we think it's absolutely inappropriate for him to be attempting to care for this child. And in fact, we believe that the child is being employed by his father in order to take care of his father, which is not, if the child were 16, maybe that would be a little bit appropriate, but at 6, with the child being in, the child isn't even in 1st grade, the child is in kindergarten at this point. We don't believe that this is an appropriate placement for the child, and we would ask that the court grant Mrs. Scobie the temporary primary physical custody and sole legal custody of the child, and provide Mr. Scobie with appropriate parenting time. Although we are concerned about even overnights with Mr. Scobie's health. If something happens to him, the child is going to be put in a bad position. We understand that the child, when Mr. Scobie went to the hospital, the child sat in the ER with Mr. Scobie for an entire day, which again, this is not an appropriate place for the child.
Okay. Mr. Scobie, what's your response?
That's one-sided bluster. She has me painted as an invalid, which is not true. I took wonderful care of him for the first 46 days that she left. Yes, I was in the hospital, but I had his 4th counseling therapy session scheduled for Wednesday. So the doctors worked with me. I got out, I picked him up, I took him to his therapy. Jamie called right after we got out of the therapy, which was unsuccessful because he was so tired, and said, I want to take Jaden. And I said, no, he's tired. He spends almost 3 hours in the car on a daily basis to get to and from school right now. And when I picked him up at school, he was so tired, he fell asleep in the car. He tried falling asleep at the counselor's therapy session, hugging me and grasping me. So my full plan was to take him home And Jamie called, asked where I was. I told her. This is a therapy session that she was invited to, but as per texts that I have here with me in the truck, she will go nowhere with me, even if it's concerning the son of ours, which is strange, but. So anyway, I said, Jaden, your mom wants to pick you up, so we're going to meet at McDonald's. And he said, no, Dad, I want to stay with you, which is normal. He hates the discord, the confusion, and the pandemonium wherever they might be staying that night. Sometimes it's her grandma and grandpa's, or her mother and father's, and sometimes it's her brother's, Dale's. And at her brother Dale's, there are 5 additional kids. No, there's more than that. There's 7 kids. And he hates the pandemonium. He has a tremendous conflict with one of his cousins that punched him in the face. He exists up there when he is there by avoiding his cousins. So we got to McDonald's. I have it all on video. And I told her I was videoing it. She had previously told me to call her attorney, which I did. I called Miss McNiff, and I explained what was happening. And I asked her why she was capable or qualified to make a determination on my health, mobility, and ability to take care of a 6-year-old. There was a 3-second pause. Obviously, she realized she didn't know me, and all she had listened to was Jamie. So I asked her if there was any court order requiring me to turn her over, and she said no. And I said, well, then I'm going to make a parental decision in the best interest of my son, who is tired and hungry. He needs a good night's sleep, and he's going to come home with me. And she didn't have a response to that, so we went to McDonald's. Jamie pulled in, and I said, look, Jaden, look who's here. It's your mom. And he turned away from the door. And his mom opened the door and said, come on, Jaden, you're going with me. And he said, no, I want to stay with Dad. And I said, Jaden? And he said, no, I want to stay with you, Dad. Previously, I'd been working with him to go up there because I want to foster a better relationship that he has with his mother right now. So I've been offering week on, week off. And in Jaden's world, that moment in the truck, he said, I want to stay with week on, week off. One day at mom's house, and then a week at your house. And then one day at mom's house, and then a week at your house. During that conversation, which I have videoed, she orders him to get out of the truck 2 additional times, total of 3. And he says no. And I said, Jamie, I'm going to take Jaden home and give him a good meal and a good night's sleep. Bear in mind, Jaden gets up at 5:30 in the morning when he is with Jamie, drives to Marshall High School with his step siblings, or half siblings, I guess they would be, drops his oldest stepbrother off, and then drives to Marley and sits in the parking lot for an hour before school starts. That's in the morning. After work, 2 nights a week, Jamie picks him up after school when it's her week, takes him to work where grandma picks him up, where he may or may not spend the night at grandma's. I got the inclination that he wasn't supposed to tell me, but he said, yes, he did spend the night at grandma's. And then other nights he spends with his uncle, aunt, and Jamie if she's there. So the custodial environment has been established. There's no doubt I can take care of him. I'm thoroughly convinced she has other motivations for wanting him. But Jaden wants to stay with me. It's where he gets the best care, the most sleep, and the most attention. Further, at wherever she's staying, she has 80 chickens, turkeys, geese that she removed from the farm, which I don't know, I thought was community property.
Okay, sir, let's wrap it up. I got a lot of hearings.
I'm sorry. Anyway, she left him. I took care of him for the first 46 days. We're trying on and off weekly. I have no limitations, and he spends more time with me than Jamie. So I don't think we should upset this until the friend of the court actually gets involved and does their investigation. That's my recommendation, but you are the authority, sir, and you know the law better than I do.
Your Honor, may I briefly respond?
Yes, you may.
Your Honor, my client does have stable housing. She is residing with her brother. It's an absolutely appropriate environment for the child. My client was not involved at all in the decision to take the child to counseling and isn't even sure why the child is in counseling and would like to have that information. Given the allegations from Mr. Scovey, I would suggest that a preliminary evidentiary hearing would be appropriate pursuant to Sanchez versus Healy, which was a 2024 case, and Daly versus Ward, 501 Mich 897, 2017. I think that this should be an in-person hearing so that the court can better understand Mr. Scovey's physical limitations and so that the court can actually have the opportunity to assess both parties and their demeanor and their physical abilities while they're in court.
Okay, well, any, I guess, truth, Ms. McNiff, to what stated by defendant that they have been alternating weeks?
They have been, Your Honor, and a lot of that is because Mr. Scovey is a very aggressive individual. When I spoke with him, he was very aggressive with me. He's very forceful. He's very adamant, and there's a big age difference. There's a big disparity in the ability to control the situation. Mr. Scovey is certainly using a lot of coercive control over Mrs. Scovey. She's afraid of him, and so she has been unable to push back on his demands with the child.
Okay, well, at this
Can I
point,
respond, Your Honor?
no, I don't need to hear anything else.
Okay.
If the parties have been alternating the weeks, we'll continue that till we have an evidentiary hearing. The court will try to expedite that, but I won't be able to get that in person in until probably sometime in early December. But we'll be in touch with Mr. Scovey and with Ms. McNiff to see what works into the schedules. I do note there was another issue in this matter as it related to the support, and apparently that the defendant was collecting Social Security disability on Ms. Scovey's other 3 children. Is that correct?
That is correct, Your Honor. It's my understanding that there were issues getting child support from those children's biological father. And so Mr. and Mrs. Scovey petitioned it to include them under Mr. Scovey's disability payments. We don't think it's appropriate now that the children are no longer living with him, that continue. And with regard to the disability payment that the parties minor child has, I can include that in any child support calculation in order to determine what's appropriate with regard to that.
Okay. Well, as it relates to the child of the parties, the court would order that disability payment would be divided equally between the parties until we have our hearing. That if he in fact continues to receive the disability on the other 3 children, that would be provided to plaintiff. But I don't think now that they're not together whether he would be getting that money. But if he does, then that would have to go to the plaintiff who has the care of the children. And we'll just continue that until such time as the hearing. So Ms. McNiff, if you want to do a temporary order, at least, pending that particular hearing.
I will do that, Your Honor. Thank you.
Okay. Thank you. You're free to go. Have a good day.
What's my understanding that I picked Jaden up after school?
Well, what you're going to do is you're going to alternate your weeks. So whatever date that the 2 of you have agreed to alternate, whatever day you agree, that's when that would start.
Tuesdays.
Would alternate the weeks until the next hearing.
Tuesdays. Okay. Thank you, Your Honor.
Okay. Thank you.
Sorry, I bugged out a little quickly.
What's that?
I left while Mr. Scovey was still speaking. I
okay.
apologize.
All he stated is that the parties were exchanging the child on Tuesdays after school. So I said, okay, we'll continue what you've been doing.
Okay, we can do that.
Okay, thank you.
Thank you, Your Honor.
16 a.m.
Court will note the appearance of Attorney Irvin on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to set aside mediation agreement relating to legal custody and for additional mediation. Ms. Irvin.
Good morning, Your Honor. As it stated in my motion, we're of the impression that the mediation agreement in this matter is ambiguous. It's ambiguous. There's two potential interpretations, my client's and Ms. Vanderpool's. The mediation agreement references that, you know, the parties will have a follow-up mediation session, and that if they're unable to agree, then they can request the court's determination. And so what Mr. Jones is asking is for the court to order additional mediation or to move the case forward to an evidentiary hearing on the issue of legal custody. Mr. Jones is requesting that the court consider joint legal custody. And the mediation agreement itself seems to imply that that was under consideration with the way that it's written, that the parties will consult. That's generally what's done under joint legal custody and not sole custody. And so we're just respectfully asking the court to have the parties scheduled for additional mediation or an evidentiary hearing.
Well, the mediation agreement says that the legal custody was reserved for follow-up mediation. So why do you need to have a motion, and why don't you just reset it for mediation?
Because Ms. Vanderpool is not agreeing to an additional mediation date.
Okay. Ms. Kurtzmeyer, why are you not agreeing when the mediation agreement says that it'll be set for additional mediation?
I'm not agreeing because it says if we cannot agree, then we are to seek court's determination.
Well, court's going to, again, the mediation agreement said that it would be continued with mediation. There would be additional mediation addressing the issue of legal custody. So the court is going to send the matter back to the mediator to have the mediator work with the parties and attempt to get resolution. If not, then we can set the matter for a evidentiary hearing.
Sounds great.
Thank you, Your Honor.
Ms. Urban, just let us, the court, know when you have the mediation reset, because then we'll set a settlement conference after that date.
Okay.
Okay, thank you.
Thank you.
24 at 9:19 a.m.
Court will note the appearance of Mr. Kelly on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to enforce parenting time order. Mr. Kelly.
Your Honor, very quickly, very briefly, this court entered an order in June. My client had every other weekend parenting time and midweek parenting time. He was exercising that all the way up until the weekend of August 16th, which he received. Thereafter, defendant has not allowed overnight parenting time over the weekend, so he's missed 4 weekends up to date. He missed his parenting time on the 4th, 11th, and 18th. Midweek parenting time, he has had some midweek parenting time since then. However, there have been a number of occasions where she's either shown up late or simply has no-showed. And when she's shown up late, she's oddly enough picked him up right on time. We're requesting makeup parenting time for the 4 weekends, Your Honor, and for the midweek parenting times he's had. I think an appropriate remedy would be parenting time to start this weekend, which would be his upcoming weekend, and allow him to keep the children for the following week through the following Sunday for his makeup parenting time. This is the second time we've had to address this issue before the court. There's clearly a court order in place. We're required to file this motion to get this enforced, to get parenting time started. We're requesting attorney's fees in the amount of $500. And lastly, Your Honor, we suspect that defendant is going to indicate to the court, well, dad's got some sexual deviance. He's got all these other things going on. She actually called CPS on him. They did an investigation. During that investigation, there was no suspension of parenting time. There was no safety plan put in place. And they've closed their investigation since then. We suspect this more has to do with her wanting to continue the marriage or relationship with my client. She has made intimations to that effect. And she also showed up at his grandmother's house where he lives, barging her way in and assaulting his grandmother, who ultimately ended up getting a PPO against him or against her. So we suspect it's not really about the children's safety as much as it's another issue relating to their relationship, which again has no bearing on this court's order. So again, we're requesting a week of makeup parenting time starting this Friday and attorney's fees in the amount of $500. Thank you.
Okay, thank you. Ms. Couch, what's your response?
My response to that, I had consulted CPS because I had found videos of children in diapers with enemas being done to them. And that is part of a sexual fetish of Zachary Conley's. And they told me not to allow visitation if I felt that it was in the children's best interest. And I feel that that is the case.
Okay, well, in this particular case, CPS cannot violate the court orders. The court will enforce its orders in this matter until such time as it's changed. You can file a petition seeking to change the orders if you have a proper cause to do so. If not, then it won't be changed, but.
I do have evidence. I'm sorry, excuse me.
Yeah, don't interrupt, ma'am. So what happens if you have proper cause, you can file a motion to modify parenting time until such time as that occurs. The court will enforce its orders. And if the orders are not followed, the person violating the orders can end up in jail. So it's a choice as to what you want to do in this matter. The court will note that it states, the motion as well states that the defendant has been late for drop off. The court will order that if in fact the plaintiff is late for drop off of the children, then the plaintiff is entitled to the time extended at the end of the parenting time. So if she's late for 1 hour dropping him off, then he's entitled to an additional hour of parenting time to make up for that. So that will be the order. The court does note, as Mr. Kelly stated, that CPS has been involved. They've closed the case without taking action. So as a result, the court would infer from that CPS did not find any basis for proceeding, or they would have sustained and substantiated the allegations. So until they do, the court simply will enforce its orders. The court will award to Mr. Kelly the attorney fees of $500 necessitated by this motion to enforce the parenting time will be paid within 45 days of today's date. Okay.
Your Honor, in regards to the makeup parenting time, what was the court ordering?
Yes, the court will, or now when your client picks the children up on this Friday,
Yes.
court will allow him to have the children for 1 week to make up for the missed parenting time. Anything else, Mr. Kelly?
No, Your Honor. I'll get
Anything else, Ms. Couch?
No. Thank you.
That will be the order. Mr. Kelly, you can submit under 7-day notice of entry.
Your Honor, even though it's being submitted under 7-day, can we make it clear that it is to be followed and she should show up for this Friday?
Yep. We'll put it and state that it's the orders to have immediate effect.
Thank you, Your Honor.
Thank you.
Hey, may I say something?
Okay, go ahead.
I am trying to get somebody through legal aid. Nobody has been willing to help me. This attorney, Michael Kelly, even worked with a mediator that he had known. And the mediation didn't go any further because they thought that it wasn't.
Okay, we're not addressing mediation now on this couch. We're addressing the orders that were in place.
Because he's an attorney. I don't have anybody, and yet he has a sexual fetish that involves children.
Okay.
He was watching children.
That's the order of the court. The order will again be in
I
effect.
will be filing against the state of Michigan.
Okay, that's the order of the court, ma'am. We're going to end the hearing now.
Thank you, Your Honor.
Okay.
24 at 9:38 a.m.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to amend judgment of divorce for name change. Ms. McNiff.
Your Honor, we did not put a provision in the original judgment of divorce that would allow Ms. Edwards to change her name back to her maiden name. So we're asking to modify the judgment of divorce just for the purpose of modifying her name back to her maiden name.
Okay, that's fine. Ms. Edwards, I'm going to take some brief testimony from you. If you raise your right hand, we'll have you sworn in.
Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
I do.
Ms. Edwards, in this matter, you sought to change your name in this case. Let me ask you, since the entry of the judgment of divorce, have you received any criminal convictions?
No, sir.
Okay. That's all I needed to know, and you're probably wondering why that's an odd question, but what happens when a person's filing to do a name change, that there is a legal presumption that if they've had a criminal conviction, that they're doing it for a fraudulent purpose. So I just have to establish on the record that you're not doing it for that reason. court will have no problem, then the court will grant the motion, changing your name from Brooke Lindsay in this matter. And did you do an order, Ms. McNiff, or are you gonna submit that?
We submitted one, Your Honor.
Okay, we'll get that entered then, and as soon as we're done with this hearing, I should be able to get that completed.
Great.
Okay,
Thank you, Judge.
Ms. Hollington, good, have a good day, and you're gonna have to get a certified copy of those orders, take it to Social Security, Secretary of State, wherever you need to change. This matter comes before the court on the plaintiff's amended motion for an in-person trial in this case. Ms. Osborne, as I read through your motion, you said that you do suffer from anxiety and PTSD. If that's the case, wouldn't it be more comforting for you if you didn't have to appear in the courtroom with the defendant?
No, Your Honor, because the PPO hearing was a complete flop. I cannot express myself well enough when I hear his voice.
Okay, well, I don't need to get into that now. I mean, the court will allow you to appear in person if you wish to do so.
Please.
I would state, however, so you know, that the defendant is not required to appear in person. He can appear by Zoom pursuant to Michigan Court Rule 2.407 (B) 4. So you can appear, but that you can't compel him to appear.
That's okay.
Okay.
Thank you, Your Honor.
Okay, we'll do that, and we'll make sure we'll set it for an in-person hearing.
Okay, thank you.
Okay, you're free to go. Have a good day.
Thank you, you too.
Thanks, you too.
Make sure we set that up after I'm back. I don't think we have a hearing trial date.
Yeah, we do, but I'll make sure.
We do have a trial date?
Yes, but I'm at 10:27 a.m.
Court will note the appearance of Mr. Midgordon on behalf of the plaintiff. This matter is before the court on the defendant's motion to set aside referee recommended order. Mr. Lane, you can go ahead.
Yeah, so the last court date was on September 24th. I was not notified of that because the court sent the paper, but it got sent back. So I had no idea this was going on or what was happening. And the front of the court has all that information. Also, I would like to be in the child's life more. I would like to go week on, week off.
Okay.
To also get rid of child support.
Okay, well, if you're gonna do that, you're gonna have to file a motion, sir.
Yes, I did file a motion.
Okay. Mr. Midgordon, what's your response?
Yes, Your Honor, my response is that the defendant attended the previous hearing in July to the best of my knowledge, and upon reviewing the file, I don't know why he would have not received a notice of hearing. I mean, his objection is just that he doesn't like what the court said and he doesn't want to pay child support. I don't think that's a sufficient basis. He doesn't allege that the referee didn't conduct an evidentiary hearing, which the referee clearly did. He followed the law. He made a finding it's the best interest factors whenever he changed custody and parenting time, and the defendant doesn't even allege that wasn't done. So at this time, I think the court should adopt the referee recommendation in order and require that the defendant file some other motion to change custody and parenting time instead of trying to use this as a hearing to change custody and parenting time.
Okay. Well, what the court's going to do, the court has reviewed the file. The court notes that the front of the court did have, again, the correct address, and all the paperwork that had been sent from the front of the court the defendant received. However, the motion regarding custody filed by the plaintiff did not have the apartment number, nor did it have the zip code on the notice in this particular case. So it does appear that the defendant did not receive adequate notice of that particular hearing. So what I'm going to do is I am going to grant the motion and refer the matter back to the referee for additional hearing in this matter, as the court does not believe that the notice was proper. So that's what we will do. We'll get that order out, and you should be contacted by the front of the court within a week or so.
And Your Honor, is that order still in effect pending the next hearing with the referee?
Well, it's in effect until the referee changes it, yes.
Okay, thank you, Your Honor.
Okay. Have a good day.
Thank you. You too, Your Honor.
Or at at 10:32 a.m.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the defendant's motion to revoke affidavit of parentage. In this matter, Mr. Carmucci, you'd stated that obviously you want to revoke that and that you wanted to do a DNA test as well. Is that correct?
Yes, it is.
Okay. Ms. McClan, you have any opposition to the motion?
No. It's to revoke child support and do the DNA testing or just the DNA test?
Well, it'd be a DNA test, but we would proceed on, once we get that, we'd proceed on the motion to revoke affidavit of parentage.
Oh, okay. Yeah.
Acknowledgement of parent.
Yeah, I'm in agreement.
Okay. Mr. Magnuson, is there any opposition by front of the court?
No.
Okay. I'll ask that the parties would get in contact with Mr. Magnuson to make arrangements so that the DNA testing can occur in this case. And once we have that, then we'll be able to set the final hearing. Okay. Anything else, Mr. Carmucci?
No, sir. Thank you so much.
Anything else, Ms. McClan?
No.
Mr. Magnuson?
Just to let everybody know, as long as we have a 4D case, which we do in this circumstance, and a known biological father that we can contact and a court order, which I'm assuming will be coming, we can do the genetic testing under those circumstances. So, I think we're going to need the name of a potential biodad.
Okay. Ms. McClan, do you have the identity of the potential biological father?
Devon Carmucci.
Oh, okay.
Yeah.
There's nobody else to list, so
Yeah.
there's nobody else to list, so no.
Okay, well, we'll do the testing on Mr. Carmucci then. Do we have an order in the file on this? For testing?
We do not.
Okay. Mr. Magnuson, could you assist in that? We don't have an order for the testing and all that. Could you get that and send it to court?
Yes, sir.
Okay, thank you. You're free to go. Have a good day, and you'll be contacted with a time from Mr. Magnuson to do the testing.
All right. Thank you.
Okay, thank you.
Thank you, Your Honor.
Thank you.
35 a.m.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. In this case, the court notes the matters before the court on the plaintiff's motion to determine child born out of wedlock and for an extension of time to file the revocation of paternity action in this matter. Ms. Crutcher, when I looked at the motion, you've alleged, obviously in this case, you've missed the limitation or statute of limitations on this by a substantial amount of time. The child is now 12 in this matter. You had 3 years to file that. You did allege, you said I was prevented from filing because not knowing I was supposed to. You also alleged a one word, you said misconduct, but you did not allege any misconduct. What did you mean by that?
I did not know what to put on there.
Okay. Okay. So why do you believe that the court should, again, make this determination now after the 3 years is not just passed, but long forgotten, let's say?
Because David's not their father.
Okay. Mr. Magnuson, anything you have to add?
I don't know that there's been ample reason giving, especially considering the amount of time that's gone by for the court to grant the motion, but I'll obviously defer to the court.
Okay. Well, in this particular matter, the court does note that, again, a person stating, well, I was prevented because I didn't know I was supposed to file. Well, that's not a sufficient proper cause in these particular matters. And the court is very lenient in allowing if somebody has missed the deadline by a short period of time. But unfortunately, the statute in this provides that the action has to be brought within 3 years. The child's now 12 years old. The court doesn't believe that the matter is timely, so the court will deny your motion in this matter, ma'am, and we'll get that entered. So you're free to go. Have a good day.
Thank you, Your Honor.
Roman versus Sebastian Roman.
Good morning to both of you. This matter is before the court there were two petitions. There was the respondent's motion to terminate and petitioner's motion to show cause. Ms. Roman, I'll let you know that in this particular case that you had to accomplish service upon the defendant. Service was not accomplished until October 16, 2024, giving him 5 days notice. That's not sufficient notice, so we cannot proceed today on your motion to show cause. You're going to have to renotice that and get him reserved, okay?
Yes.
Okay. We can proceed, however, on the respondent's motion to terminate, as that was timely filed and served. So we will do that. Mr. Roman, I'll have you raise your right hand and we'll have you sworn in and you can give some testimony.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Okay. Go ahead, sir. Why do you believe the court should terminate the personal protective order?
Well, the first part is I'm not a danger or a threat to this woman. I've never really done anything other than argue with her, and that's really all. And, you know, we've gotten loud and all that, but I never physically hurt this woman. I've never put my hands on her. I still love her to death, and I would never do anything like that.
Yeah.
I just wholeheartedly, I just want this all to be behind us so me and her can respectfully just go back to parenting our kids and just however it happens, you know. I just want this behind us. I don't wish any harm towards her or anything of that nature. I just want to be able to see my children and move on with our lives.
Okay. Anything else?
No, that's really it. I mean, like I said, a large amount of these statements that you claimed against me, they're all mostly extremely exaggerated. I've never spoken to my children in this way, telling them to, I don't mean to curse, but telling them to shut the fuck up or I'll slap the shit out of them. You know, I've never said anything like that to my children. And the fact that she would lie and say these things about me is ridiculous.
Okay. Ms. Roman, do you have any questions of the respondent?
I don't have any questions for him.
Okay. Ma'am, what we're going to do is we're going to have you raise your right hand, be sworn in. We'll take some testimony from you.
Please make sure you unmute first, please. Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes, sir.
Okay. Go ahead, ma'am. You had, I take it you don't want the personal protective order terminated. Is that accurate?
No, I do not. I do not. My statements are not exaggerated. They are true. I have presented evidence to the court. There was a long abuse of sexual abuse. It is true. Everything I'm saying is true. I have proof of whatever it is that you need to show me. He's saying that he never physically touched me or anything. You have, and I have messages between the two of us where you admitted of the things that you've done.
Okay, sir, ma'am, direct your questions and your comments to the court, not to the respondent.
I'm sorry, sir. I do have proof of text messages between the two of us.
What proof do you have? I'm looking at your petition, and let's go. The first incident you mentioned was on 9/19/24.
Yes.
And tell me what happened on that date.
On 9/19/24, we got into a dispute that day, and I told him I was getting my car, and I went to his job and I got my vehicle back. I called the police when I got home to let them know that there was going to be a possible altercation because of that. So I forewarned the police before anything happened. At approximately around 9 o'clock, I was putting my kids to bed. He came in the house storming, screaming, and yelling. And he drugged me into the room. You cannot say this isn't true. I have witnesses. I have my brother and I have my mom who was also here during this event. But he drugged me into the room. He pushed our daughter out the way because she was following behind us. He got into my face, was yelling at me about the car and everything. He threatened to punch me and break my jaw. This is true. This is everything that you said that was said. And he was trying to take my other vehicle. So he stormed and went and got my keys out of my purse and I chased behind him. I also have messages to found two witnesses that was outside that seen this altercation outside. We got into an argument then. He was screaming and yelling at me outside, causing confrontation. He said he had items in the car that I took. I agreed to go get the cars. I mean, his items from the other car, which is the Pathfinder. And I told him to meet me at the gas station. That was our proof. I mean, not proof. Excuse me. I'm sorry. That was our agreement, was for him to stay at the gas station, and I will go retrieve whatever he's supposed to have in there, which wasn't nothing but 2 packs of cigarettes and some weed. But I told him I'll go get his stuff and I'll meet him back at the gas station. He had 2 girls in the car with him, and the back of this gas station was behind my home. So I went and I noticed that he was following me. I stopped in the middle of Dickman Road and I told him that you're not going to follow me. So I made a U-turn to go back home, and he followed behind me and crashed into the back of my car. Afterwards, I got out of the car and he was pushing me and stuff. And then his girlfriend, after my brother came and got him off of me. And then me and his girlfriend got into an argument, and she proceeded to fight me. And another girl who they had with him also jumped on me. And again, I got my mom and my brother here as a witness as well. So he did bring 2 females to the house with him. And to my understanding, it was to harm me, because why are you bringing 2 women to the house? And he's saying he didn't, but how do we get into a fight behind the house if you didn't bring 2 women there who know where I live and where our kids lay? And then he came in the house and made a big confrontation, pushed our daughter physically out the way, and drugged me in the room, and then threatened to break my jaw.
That's lies.
That's not a lie.
Sir,
It's not a lie.
no comments by you. She's testifying.
It's not a lie. And I have, like I said, my mom has been here for almost 2 months now. She's seen the way you stormed in the house. They've heard you yelling. So I got people to testify against you. You can't tell me that it's not. They're here and they've seen and they witnessed. It's not a lie. You know this is what you said.
Ma'am, do not talk to the respondent. It's an address your comments to the court.
I'm sorry. It is everything that I'm saying is not a lie. It is true. And that's what happened that day. And even in the police report, it stated.
Well, I don't care what's in the police report. The police report is just a statement of what the parties have said. So that's not evidence of what's in the police report.
Okay. Well, I have witnesses.
Okay. Anything else, ma'am?
Are we just talking about that, or can I move on to my other statements?
You can move on to anything you'd like to the court to be aware of.
Okay.
May I address that first statement?
No, you can't. She's testifying. When she's done, you can address things.
Okay, thank you.
Moving on to the sexual abuse. All of that is absolutely true, and I have to deal with it for months. I have text messages with me pleading with his mother, with his aunt. I have messages between me and him talking about all the sexual abuse that he's done towards me. Everything that I said is absolutely true. Every night I would be sleeping in my room, and he would come in to my room on August 23rd. And that day, I told him that I would call the police on him. And he's trying to get into the Air Force. What he told me is that he don't care, that he would tell the police and his sergeant that it was worth it. Those are not lies. And I put my right hand to God, and I put that on my kids. I would fight with him every single night for months, with him coming in my room and violating me. And I have text messages between the 2 of us of me telling him to stop touching me, stop violating me. I have witnesses of my brother seeing him have me hemmed up in the corner. Anytime I would try to get away from him when we arguing, he would hold me up, he would choke me. Yes, he would. None of this is not a lie, it's not exaggerated.
Okay. Anything else, ma'am?
Can I show proof of text messages or anything?
Well, if you have those and they are readily available.
I can print them out for you.
Oh, okay.
They're loose, unlabeled, so that's what we get.
Okay. We do have some things that you had provided, but you'll have to be specific, so because they're not labeled in any way, so.
Okay.
Go ahead.
I have, let me see if I can turn my camera. Sorry, because I'm in my car, so I do apologize. I have messages from August 23rd. I'm trying to figure out how to turn my camera so I can show. How do you flip this camera? Right here. Okay. Here's messages from August 23rd. And I'm right here. I'm explaining exactly what he was doing to me that night. And excuse the language on there. Where it
Okay.
says about
Well, let's clarify, ma'am. You said that you had stuff from him. I'm not as concerned about what you said happened because you've already testified to that.
Okay. Yeah. Well, this is me. Everything I said and basically about what he did is what I said in the text messages. And here he admits right here. Okay, what I did, and it was foul of me to do it, but my heart broke.
Okay. Hold on. I'm not finding. How do I identify what you're pointing to there?
Is him responding back to what I'm saying he's doing to me, and him saying that he's admitting that this is what he did.
That's not what I'm asking. I'm asking, how do I identify it in the paperwork you gave me? I think I've identified that. It's,
It should be the second page of that.
well, it's not the second page. I think it looks like it's the third page of what you had provided to the court. It says, I think the response is, okay, what I did, and it was foul of me to do it, but my heart is broken and my mind destroyed by all that is unfolding in my life, and I wanted to keep something in my life. Is that what you're referring to?
Yes, he's admitting that what he did.
Okay. Okay, anything else, ma'am?
Yes, I have messages of me constantly telling him to stop touching and violating me.
Okay, I don't need those because that's your statement. And again, you've already said that. So if in fact he acknowledged or did anything to that extent, then that would be important.
Okay, well, I don't have anything else. I just have messages of basically showing how overly obsessive he is, how I've been basically just trying to get away from him this entire time. I have messages of me basically him telling me that he's not going to leave me alone no matter what.
Okay. Anything else, ma'am?
That's all. Just me just showing that he's basically saying he wouldn't leave me alone. I just feel very threatened by him, and I just don't feel like I need to be around him. I don't want to be around him.
Okay.
I've been trying to get away from him for years, and it's been overly obsessive, and it's been a long line of all type of abuse, physically, verbally, and I just gotten to the point where I'm trying to come to help. And if y'all terminate this PPO, I feel like it's gonna put me in danger because a lot of women that come for help and they don't get the help, and I'm trying to get the help right now. I'm trying to stay away from him. I'm trying to be protected right now.
Okay. Sir, do you have any questions of the petitioner?
Are you referring to me?
Yes.
My main question is, well, not really.
Well, you either do or you don't. Not really isn't an answer.
I do. Would I be able to see my children, or would I be able to get this terminated? Because I don't wish any harm towards this woman. Nothing like that. I don't want to. I'm never gonna put my hands on her or anything like that. And also, I do have a secondary question. The addresses that are presented on the PPOs, I've been made aware that my ex-wife has moved residences, and I don't know where she lives now. I don't really care where she's at. I just want to know where my children are. That's my only concern. And also,
we're not taking care of that in this proceeding. This is only on the motion to terminate.
I understand that. And also, I'm currently homeless at the moment. And since she's not residing at our former residence, I was wondering if the court would at all make it possible to allow me to remain.
That's not before the court. If you want that, you're going to have to file a complaint or a petition to get that relief, but it's not before the court today.
Okay.
Okay. Anything else, Ms. Roman?
No, sir. I have all the evidence that I have provided. Like I said, I just want to be able to be protected.
Okay. Well, in this particular case, the court's heard the testimony of the various parties in this case, and I will let you know that the court can enjoin and restrain certain conduct if the court determines there is reasonable cause to believe that an individual has committed or may commit any acts listed under MCL 600.2950 parens 1A through K in this particular case. And in this particular matter, there are obviously allegations, there's denials of the allegations, but the court notes that the petitioner had referred to some text messages in which she had made various allegations against the respondent in this particular case, to which his response was, okay, I did, and it was foul of me to do it, but my heart is broken and my mind destroyed by all that is unfolding in my life, and I only wanted to keep you in my life. Obviously, the court notes, obviously in view of the allegations that he had engaged in the conduct which he has testified to today, clearly that's an admission that, as he states, it was foul of me to do it. The court does believe that there is reasonable cause to believe that he has or may commit any of those particular acts, so the court will, in this matter, deny the motion to terminate in this particular case. So,
Your Honor, if I
you may not. We're done now. The personal protective order will continue and remain in effect through the date of the personal protective order. So you're free to go. Have a good day.
If I may, so what would I tell my sergeant? Because he wants to know if this is a pending sexual assault charge against me, and she claims that I have a warrant for my arrest as well. But
I have no idea about any warrants in this matter. All I know is about What's under the personal protective order?
No, because she's claiming that I went to the house, but I never went there.
Well, she can claim anything she wants. I'm continuing the personal protective order, and that's all we were here for today, sir.
Okay, but when will the address be changed for her protective order? Because, you know, obviously she doesn't live here, and I don't want
Well, she's gonna have to file something to get that amended or modified. The only thing we had on today was your motion to terminate. We didn't terminate it, so.
Okay. But,
Okay, free to go. Have a good day.
Let me see if I might have the other one here.
Well, let's wait. Don't want to hold them up.
Okay,
So where are we at, Ms. Downs?
no one.
Okay,
1 second here. Let me get this person back in. So can I call the cases?
oh yeah, call McKee.
Give me 1 second. I have to change a setting here so that when you speak, it'll pick you guys up too.
Maybe we don't want to hear them though.
Maybe not. So this is Summer McKediak versus Mark McKediak. It's neither party is present, but we have prosecutor's office and Mr. Sackrider for the public defender.
Well, good morning to both of you, and thankfully the both of you showed up. We have no parties present. This matters before the court on the petitioner's motion to extend the PPO and for show cause for violation. The court did set this matter for an in-person hearing, and both parties were notified of this fact. And in fact, Ms. McKediak would have been notified at the last hearing when she appeared, but the respondent did not. So Ms. Towns has again called the hall, and the petitioner is not present. Anything from you, Mr. Sackrider?
Yes, Your Honor. At this time, we would move to dismiss the motion as well as the show cause for failure of petitioner to appear today.
Okay, Ms. Towns, any response?
Of course, with Ms. McKediak not being here, it's hard to oppose that. The only thing I would indicate is that that if the respondent has had a history of not appearing, and even though she's not here, I don't think that he should be off the hook and not have some accountability for not appearing.
Okay, well, the court had, in this matter, he had not appeared at the last hearing. The court did enter a bench warrant at that time when we reset the matter to today's date. So that bench warrant is still out. The court will, based upon Mr. Sackrider's motion, I will dismiss the motion to extend and the show cause in this particular matter because the parties were required to appear. The court will again dismiss both of those motions at this particular time with prejudice because they had adequate opportunity to appear, did not. But that doesn't take Mr. McKediak off the hook because the prior hearing where he was supposed to appear in person, he did not. The bench warrant did appear. Mr. Sackrider stated his client intends to, surrender himself later today. We'll see if that happens or not. I guess if he doesn't, Ms. Towns, the court would grant in this matter a arrest warrant if you wish to proceed in that particular matter because he's not appeared today, regardless of the outcome of the petition that the petitioner has not proceeded because he has that bench warrant. He also has another outstanding bench warrant as well. So we need to get him before the court to take care of those matters.
Very well, thank you.
Thank you both, and free to go. Have a great day.
You too.
Thank you.
So we have one more here. Is this Mr. Please unmute. Is this Mr. Serban? Oh no, that's Summer.
No.
That's
Nope.
Summer. You're Summer McKediak, right?
Yes.
Okay. Hold on.
Well, Ms. McKediak, what happened is we waited and you did not appear. And so what we did is we dismissed the case.
Me?
Yes.
I've been here since 11 o'clock. Sitting here. What do you mean? I called this morning at 9 a.m. to verify the time, and I've been on Zoom since 11 o'clock waiting on the waiting room. You switched over to answer one time, and by the time I turned my video on, it was back to the waiting room again.
Okay, well, Ms. McKediak, what you're going to have to do is, unfortunately, you're going to have to refile.
I've never missed a court hearing in my life, sir.
Okay.
You know, you've worked with me several times. I've been on this whole time.
Okay, ma'am, I'm not debating that point. I'm just saying at the time when we came on at 11 o'clock, we didn't have parties for a lot of the hearings. We never saw you. So we waited. We had, well, plus the hearing was supposed to be in person. So you would have supposed to have been here in person. We had the prosecutor go out and call the hall multiple times. You
It
weren't
was
here.
on Zoom last time. I thought only Mark had to appear in person.
No, we put on the notice that it had to be in person. The parties appeared.
I paid $60 to have this done. You know how many problems? I have to file another violation on him this morning.
Well,
Like, I need this taken care of today. I had no idea I could be at the courtroom in 5 minutes. If you would have
we've already dismissed the attorneys. It's now 11:27. We dismissed them because nobody appeared in person. The notice clearly says parties to appear in person. So we
So
dismissed
am I
that.
just filing for another motion to extend?
You can file another motion to extend or refile that one because we'll note that you did appear, but we didn't know that because it was supposed to be in person.
Yeah, and I think I'm just gonna have Matthew deal with these from now on, because this is exactly why I didn't want to do this one on my own, but they said I didn't need my attorney, so I'm just gonna involve the attorneys from now on.
Okay.
So I'm just
Okay.
gonna go up, and it's just a motion to extend, it's not for the violation. The violation was
You can
already-
you can file what you want. We're not saying you can't file anything. You can file what you want, but the reason we didn't get on Zoom to look for you is because it said in person, and we
I
stated.
thought that meant the defendant, I'm sorry.
We stated at the last hearing that the parties would appear in person.
The prosecutor had asked for Mark to appear in person because of his failure to appear all the time.
We said that we
know
wanted
that.
the parties to appear in person.
Okay.
And notice says parties appear in person, so.
Yep,
that's all I can tell you.
I'll call Matthew and just file another one.
Okay.
All right,
Go
thank you.
Yep.
I was just telling him to say, have her just call us,
Okay,
but it sounds like she's gonna.
yeah,
Good, call your attorney, not have to deal with it.
yeah.
I mean, we
That's
said,
even better.
we said in person for all.
Yeah, and I get why she was confused, but again, it is what it is.
Yeah. Yeah.
It's all right, we'll get it
Okay,
fixed.
we don't need to call this last one. The defendant did not appear.
Oh, defendant did not?
No,
Mr. Cervantes.
yeah, and that's his motion.
Yep.
Sorry about the wait, ma'am. We're gonna call your case now. This is 2024.
Mr. Cervantes, or Ms. LaBeouf, it is now, as he stated, 11:30. Was set for 11 o'clock. Mr. Cervantes has not appeared. As a result, the court will deny and dismiss his motion to terminate.
Okay, thank you so much.
So the order will remain in place, okay?
Okay, thank you so much. I
Okay.
appreciate
Malwa Rental.
Thank you for
Enterprises in
appearing.
Portage Lakes versus Cross Refrigeration and Austin Cross. Attorney Brittner for the plaintiffs. The defendants are not here.
Mr. Brickner, good afternoon.
Good afternoon, Your Honor.
I note that you completed your alternate service on September 25th. What's happened since that time?
I've heard nothing, Your Honor, but actually, when they did the alternate service, they actually physically served the defendants. They got the alternate service. They also said they served him personally.
Oh, okay. Well, that's
what,
good.
That's what the proof of service said. So their 21 days just ran out late last week, so I was going to file a default.
Okay. Well, we'll let you do that and then see what happens at this point.
If may I ask the court, will you allow me to send a default with a default judgment, or do you actually want testimony?
If you are varying from the numbers in the complaint, then we're going to need to take, basically file a motion, et cetera. If the numbers are the same as in the complaint, then we'll be able to do it on a default.
The only thing that's going to change is the court costs.
Well, that's understandable. That's what
The
I think
service
this as
fee
well.
the service fee was like $529. Whoa!
I think you set a record there. I don't think I've ever heard that.
I've never seen it before, but I paid the guy. He found him. That's a good thing, I guess.
Yeah.
Okay, then I will file a default and default judgment, Your Honor. And if that's satisfactory, just ask the court to enter it. If not, then we'll schedule it for a hearing.
Okay. Okay. We'll check and see what happens.
All right, I'll get that done this week, Your Honor.
Okay. Thank you.
Thank you very much.
Bye.
It's nice to see you, Your Honor.
All right, thank you. Let's move on.
Did we do, there's an order in here, order to determine child born out of wedlock on Godier versus Salem.
That was the referee did it last week.
Referee did it?
Yes. Mark should have signed off on that.
Yeah, I've got nothing in the order that's showing that the referee did anything. That's why I wondered.
I saw him in his sign queue. I guess maybe send it back to him. Because they did the hearing on the 15th.
Oh, he did initial it.
Oh, yeah, that's what he, yeah. So
Okay.
it is good for you to sign. So
Okay.
plaintiff.
Okay. Good afternoon to everyone.
Good afternoon, Your Honor.
My understanding, based upon what we've heard, is that that you got resolution and that you settle. Is that correct?
Yes.
Mr. Todd?
Yep, absolutely, Your Honor. We have a signed judgment and a signed child support order, and that has been submitted to front of the court for approval.
Okay, great. What we'll do is we'll take some testimony from you, Ms. Hoffman. Have you raised your right hand We'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay, go ahead, Mr. Todd.
Ms. Hoffman, do you remember signing a complaint for divorce?
Yes.
At the time you signed that complaint, were all those allegations true, and do all those allegations remain true today?
Yes.
Did you live in this state for at least 10 days and or live in this state for at least 180 days in the county for at least 10 days prior to filing the complaint?
Yes.
Have you had an opportunity to review the proposed judgment and believe it equitably divides all of your assets and debts?
Yes.
Are you currently pregnant?
No.
Do the custody, parenting time, and child support provisions, are they in the children's best interest?
I believe so. Yes.
And has there been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Would you briefly describe for the court why that is?
I believe that we just came to a point where we didn't see eye to eye anymore with our marriage.
Okay. Nothing further, Your Honor.
Okay. Mr. Hoffman, is it your understanding as well that you did reach a resolution at mediation?
Yes.
Okay. Well, the court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. And as a result, the court will preserve the proofs in this matter pending receipt of the approved paperwork in this matter. And you're still divorced until such time as the court receives and signs that after we have the approvals from the front of the court, etc. So with that, is there anything else, Mr. Todd?
Nope, nothing further, Your Honor. Thank you.
Mr. Hoffman, anything else?
Nope.
Okay. Thank you both. You're free to go. Have a good day.
Thank you.
Thank you, Your Honor.
All right, thank you.